planned on Friday to publish a new installment in what for us has been a very long-running series of articles about the arms deal. We approached Mac Maharaj to inform him that we were going to run the story reflecting on his own conduct and what happened in an interview between him and the Scorpions, as well as some documentary evidence. And he initially just asked us, where did you get the information from? He didn't reply. We then got a letter from his lawyers effectively threatening us with criminal prosecution and other court action potentially if we went ahead and published the story. So we took advice from our lawyers and very reluctantly decided, just as we went to press on Thursday night, that we would have to redact large portions of the article because the law in question, which is called the NPA Act, makes it an offence to disclose information that's obtained from the special interviewing process called Section 28, an interview under oath in terms of an NPA investigation. And unfortunately, there's no public interest defence for disclosure of that information, so we simply would have been prima facie potentially in breach of the law. Mac Maharaj is making a big noise about criminality on the part of the Mail and Guardian simply to divert attention from the fact that he lied under oath to the National Prosecuting Authority and that he's got a lot to hide. Now, on the legal technicalities, we don't believe we've committed any crime, and we think he's getting it wrong when he says that we have committed an offence simply by being in possession of this material. So we've broken no law, and we will continue to fight for the right to publish this story. Section 28 of the NPA Act really sets out some pretty wide-ranging powers that NPA investigators have. And they would have been the kinds of powers that the Scorpions used when they still existed, which include the right to subpoena people to come and testify under oath, to be interviewed under oath as part of an investigation. Now, that information isn't supposed to be used in court unless it's for charges against the person concerned, and it's to help them build their case. It also gives them effectively search and seizure powers. Pretty controversial section of the legislation. Many of those who were investigated along with President Jacob Zuma around the arms deal complained bitterly about that section, saying that it violated their rights. Now, the difficulty that we face is that another section of the Act, Section 41, makes it an offence to disclose any information that's gathered during the Section 28 process. And there's no public interest defence clause. There's no way that you can go to a judge and say, look, this information was of vital public interest. And we need to be able to tell our readers, you've simply committed a crime if you disclose it. There are obviously reasons to protect in-camera information, and so one can understand some limitation there, but this limitation is incredibly sweeping and broad. And because it prevents us, and we have a very clear, concrete example of it right now, it prevents us from telling the public the truth about serious wrongdoing in high places. Clearly that can't be right under our constitutional scheme. It's very, very similar to what the Protection of State Information Bill, also sometimes called the Secrecy Bill, will do, in that it imposes a blanket ban on publication no matter what the motive and no matter what the information might reveal. I think what's happened this week gives you a very clear sense of what it's going to be like to live under the Secrecy Bill if it's adopted without a public interest defence clause. It's going to force newspapers and even activists and other people who want to get information out to the public to hold back when they really should be exposing serious crimes, corruption, maladministration, hypocrisy. And it really goes against every fibre of one's journalistic being, and indeed against, I think, every core value of the Constitution to impose that kind of limitation. Well, we're going to go through the legal process. We'll apply to the National Director of Public Prosecutions for permission to disclose this information, and we really hope that he will show his commitment to transparency by granting that permission. If he doesn't, then a further court process will have to unfold.